Hello everyone, good morning. Today is 12th of November and welcome to the Hindu newspaper analysis discussion. So guys, in the today's video, we are going to discuss the entire Hindu newspaper. We'll take all the articles with the background. We will be taking the detailed way forward also. Now, before starting up, I would like to tell you that you can download the explainer PDF. In the explainer PDF, the notes of all the articles that are relevant, it has been given. Editorials has also been discussed, and in the last, a mains practice question has also been given. So you can download this explainer PDF. Now the link for this PDF is given in the Telegram channel, and the link for the Telegram channel has been given in the description box in YouTube. Moreover, you can visit the Telegram directly and can search there Thinking Palette by Sahil. There also you'll get these notes. Now, before starting up, first of all, let's see the overview of the entire newspaper so that we can understand that which articles are actually important in the today's newspaper. Okay. First of all, I want to apologize. We are a little bit late today. The reason being that I was a little bit under the weather, not feeling well. Okay. So the first article, Supreme Court orders the release of all the life convicts in the Rajiv case. Fine. Now you see this particular thing. This particular article has one political dimension. Fine. Then there is one academic dimension in this particular article. Now we need to see the academic dimension where the powers of the governor and the issue, the controversy that was there, that is something we need to see. So we'll take that particular article. Centers silence on judicial postings commendable, condemnable. Supreme Court. Now, why they are condemnable? What has happened? We'll take that. Then moving on. After that, in the city section, there are the regional issues. Okay, all these things are not important. Moving on. Advertisements, the regional, state level politics, etc. has been given. Now, guys, here just you see this particular thing. Just we can use this particular example as a case study in our answers. So we see this thing that every year around the month of the October, November, there is the winter pollution problem that starts into the Delhi and around the regions. The biggest region is the stubble burning that is carried into the Haryana, Punjab and the Western Uttar Pradesh. Now, to tackle that particular thing sustainably, what has been done? The Punjab is signing an agreement with the Kerala, and the paddy stubble will be provided to the Kerala, and Kerala will be using that paddy stubble to meet the fodder shortages that are there in the Kerala. Is it clear or not? So guys, this is just a one-liner example that can be used in our answers. Then moving on, coming to the editorial page, EWS verdict, we'll see this article, measuring trade. Now this particular article is talking about, now what has happened, India's export import data should be consistent, the timing needs to be predictable and all such kind of a thing. Okay, on that day 15th of every month the data should be released and all such things. Now the article doesn't contains any exam specific kind of thing. Then autonomy oils the wheels of the higher education, we'll see this article. Fine. Research first. So this article talks about recent changes that have been brought with respect to the research, the PhD students will see that, and what will be the implications also we'll see. Now today is Saturday, and on the Saturday this ground zero report comes. Now this ground zero report covers an issue from the ground zero, the personal accounts of the people. It is taken on the substance abuse trail in Kerala. Okay, now when we talk about this particular article, guys, if you have an interest you can read this, but the ground zero article majorly it is telling the stories of the people and all such kind of things. So much academic substance in this particular article, fine, is not there. Then Supreme Court orders the free convicts in Rajiv Gandhi case is erroneous. DMK hails verdict and says governor can't sit on the resolution. So we'll see that how the governor's role is coming in between. Then after that, moving on, the political articles etc. not very much important for the examination. Fine. Moving on in this particular direction, guys, morbid tragedy, Congress NCP alliance, government started drafting bill to add Hattis in the state ST list in the Himachal. So guys, in the Himachal impending elections are there. Okay, and it is also being said that just as an electoral stint, many new communities are being given the ST status, but on another hand it has been said that this need was pending from long time. Fine. Then moving on, Supreme Court extends protection around the area around the shivling. Okay, so basically now guys understand Gyanvapi mosque dispute, fine, and all these kind of things. For the examination you need not to go too much into the details in such kind of things, because there is also the politicization of such things that has also happened. Courts must take up civil suits against hate speeches, ex Supreme Court judge. Now altitude decides Simeon's attitude to diet. Now guys, what has happened, there is basically there is a study that has been published, and the study is talking about that basically Himalayan grey langur. Okay, when their height will change, okay, their food preference will change. Okay, if they are at more height, they if when their height changes, sometimes they will be consuming the sometimes they will be consuming the fruits, sometimes they will consume the flowers. So fruit or the flower, what they are consuming, it depends often onto the height. Now basically understand these particular things, that on what height what animal is consuming what. Fine, these things are not something which are very important for the examination, so you need not to go in that particular direction too much. Fine, I hope that you are understanding. See, basically the environment ecology is important, but the species, fine, they are now behaving in this way, a particular species behaving in that way, that much microscopic information is not that much required. Kherson is ours, says Ukraine president as Russian forces retreat. So basically, as the Russia-Ukraine war is going on, the Kherson, fine, one of our province within the Ukraine, Russia has retreated from that. Fine. Now understand one particular thing, that you don't need to follow too much into the detail as every day where the war is going on and all such things. Yellen pushes for global cooperation on the regulation of cryptocurrency. We'll see that. Fine. Then Modi's pair India's growth outlook to 7%, and then these are the corporate trends etc. that has been given, not important for the exam. And then we have the weekend sports page. So this is guys the overview of the entire newspaper, and now let's discuss all the relevant articles one by one in the detail. Okay. Now, so every class we start with a GS quotation, and these GS quotations can be used in your answer writing. So today we'll take the quotation from Dr. B.R. Ambedkar. So Dr. B.R. Ambedkar says that political democracy cannot last unless there is at the base of it a social democracy. Now you see this particular thing. Political democracy, it is to have a constitution, and within the constitution establishing the liberal principles, equality, justice, liberty, fraternity, developing the institutions. That is good, fine, a political democracy is good, but we need to have the social democracy as well. It means that at the societal level every person needs to be given the opportunity for participation, for deliberation. Fine, every part of the society needs to be given their due share. So the social democracy is also very much important. Fine, so this idea can be used in the GS paper number 2 as well as in the topics of the essay, that the quotation can be utilized. Fine, now let's take the first article. Now here I have clubbed two articles, two of the, just a minute. Here I have clubbed the two articles, both of them have come into the newspaper. Number one, Supreme Court orders release of all the life convicts into the Rajiv case. DMK hails verdict, says governor can't sit on the resolutions. Now we will be taking it, we will be taking only the academic aspect of this particular article, which is important for the GS paper number 2 polity and related issues. So we'll take this particular topic with respect to the GS2, issues related to polity. Issues related to polity. Okay, now before going in this particular article guys, I want to give you little bit of a background, because if you don't know the background, this particular article will just be one liner factual thing that okay, convicts have been released, Congress is unhappy, then there are some people have justified it, but that is not something which is going to help us in the exam. Fine, so let's take some of the background. So basically, former Prime Minister of India Rajiv Gandhi's assassination was carried in 1991. Now this was a planned assassination, and there was an elaborate plan that was made behind that particular thing. So what happened? On the charge of murdering Prime Minister, former Prime Minister Rajiv Gandhi, there were certain people who got arrested, and out of them the 7 people got convicted. 7 people got convicted. Fine, now these 7 people are convicted and they are in the jails. Now understand this particular thing, that what has happened, one of a convict first of all let me tell you a little bit more about this particular thing. Basically guys, when we talk about the pardon, the power of pardon has been given to both the President of India as well as governor. Now in this particular case, the governor will be coming in between. So we have the article number 161. Now as per article number 161, governor can use the pardoning power and can give respite, remission, commutation, fine, in these particular matters. So what happened, these seven convicts they had applied for the pardoning to the governor. They asked the governor to use the powers under article 161 and should pardon them because they have spent a lot of time in the jail already, number one. Number two, these people had said that though the assassination was carried, but the role of these people is also to be considered, that to what a degree they were related to that particular case, that is also to be seen. Thirdly, it has been provided that these people's conduct into the jail was something which it has been said that into the jail their conduct was not very bad. They had also done the degrees, they had, one of them has also published the poems also, and for that the national award also that one of a person has won. So they applied to the governor that they should be given the pardon. Okay, now guys, understand this particular thing. Governor's pardoning power, he cannot use that particular power independently, but in this particular capacity, uh, the the governor will be acting on to the advice given by the government as well as the council of ministers. Now what happened in 2018, Tamil Nadu Council of Ministers, fine, the Tamil Nadu government gave the approval to the governor that governor can pardon these people. But what happened? Governor did not take any decision on that particular matter from 2018 up till now. Government has not done any particular thing. So there is a kind of an inordinate delay that happened. So first of all, there was a lot of delay. Then secondly, what happened? Governor, rather than taking the decisions onto the advice tendered by the Council of Minister, Governor forwarded this particular matter to the President of India, and then the President of India has not taken any decisions for nearly 2 years. So basically, this is a matter that is coming, that the pardoning of the people who have been convicted, it is not being decided into the timely manner. Fine. So as this particular issue was going on, one of a convict out of these seven convicts reached to the Supreme Court. Fine. One of a convicted reached to the Supreme Court and said that though the Tamil Nadu government has given the approval in 2018, governor has not taken any decision. So Supreme Court, what it did, Supreme Court gave used the Article 142. Now, first of all, what is Article 142? Article 142 gives extensive power to the Supreme Court. It is provided that Supreme Court, in order to do complete justice, can pass any order, can pass any decree. That is something which is provided. Is it clear or not? So Supreme Court used the Article 142 and released this person whose name was A.G. Perarivalan. His name was A.G. Perarivalan. He was released. Okay. It was said that governor has not decided on to the mercy petition for such a long time, and it is a valid ground that you will be released. So this particular person, A.G. Perarivalan, was released. Now, as this particular thing has happened, the other convicts also has approached the Supreme Court, and they had said that their matter also has not been decided for such a long time. Neither the governor nor the president has taken the matter. So what about us? So now the Supreme Court has released these convicts also. Okay, so this is, guys, first of all, the entire background of this particular article, and if we don't know this particular background, then reading this particular will not make much of a sense, because here just is provided that these are the 6 people who have been released now. One of them got released earlier. Okay, so this is, guys, the entire issue that is coming. Now see this particular thing. I told you that there is article number 161. Now, basically, Article 161 talks about governor's power to pardon or remission. Now, the question comes that what is the real scope of this power of pardon or remission? Will governor be using this particular power independently? Is it a governor's discretionary power, number one? Or is governor bound by whatever the state council of minister are saying? Or can governor refer that particular matter to the President of India, or will the governor be acting only on what the president will say? So this is a question that has been there, which have surrounded around the article number 161. Now I told you already that the A.G. Perarivalan was released in 2022, that was into the May 2022, he was released. Fine. And in 2018, Tamil Nadu cabinet had recommended that all the 7 convicts were to be released, but the governor did not acted on that particular advice. Rather, what governor did, first of all, governor did not took any decision, and then governor referred the matter to the president. Now in this particular May judgment, that is the Perarivalan judgment that has happened, here the Supreme Court has provided this particular thing, that the state cabinet's advice was binding onto the governor as per Article 161. So governor has to act as what the state cabinet has said, and state cabinet recommended already in 2018, and up till now, because they are not released, now the Supreme Court is releasing them by using the Article 142. Fine, because this is a matter where the Supreme Court can issue any degree. So this is, guys, the entire issue that has happened. Fine, I hope that you have understood this particular article. Fine, now see this particular thing, that when we talk about the scope of the power of governor, the scope of the power of the president, okay, now their powers are first of all very much limited because of the ceremonial position of these particular offices. Now the governor's powers actually have also become a controversial one, because we have seen this particular thing, governor who acts as a linchpin between the center and the state. Often it is said that the governor becomes a partisan also. So this is also one of a area where it has been said many number of times that governor was acting in a partisan capacity. This is something that has happened. Fine, one thing moreover, guys, understand this particular thing. What is the role of a governor? Now understand, there are many controversies on that particular thing. Often it has been said that number one, governor is the agent of center. At other times it is said that no, governor is not the agent of center, governor is rather the linchpin between the center and the state. Supreme Court says this particular thing, that the governor is a constitutional authority. Yes, it is a constitutional authority, because clearly it's mentioned into the constitution. But what is the meaning of this word, agent of the center? Now this word is often used along with the office of the governor, because many a times it has been seen that the governor acts on to the behest of the central government and doesn't gets aligned with that what the state government is talking about. So this particular acronym, that governor is the agent of the central government, many a times it comes into the news also. Okay, so basically when we talk about the answer writing, in the answer writing, when we are going on critical on the role of governor, you can use that many a times it acts as the center of the government. Okay, so guys, understand these particular things. All these expressions have a role in a particular capacity. Okay, now moving on to the next article. Centers silence on judicial postings, condemnable Supreme Court. Okay, condemnable Supreme Court. Actually there are two words. Fine, don't get confused. One is commendable. Commendable is to appreciate something. Condemnable is to criticize something. Okay, now actually guys, when we talk about the higher judiciary, in the higher judiciary we have the High Court and we have the Supreme Court. Now when we talk about the High Court, understand this particular thing, that there are huge vacancies in the High Court that is there. Now first of all, to tell you this the extent of the problem, I have used here one of an infographic, and here we have taken the data from the September 2022, that was the case. Okay, now before going in this particular article, first of all, the utility of this article will be in GS paper number 2, issues related to judiciary. Now see, actually when we talk about the higher judiciary, it has been provided that there are a lot of judicial vacancies, and specifically the former Chief Justice of India, Justice N.V. Raman, has emphasized on the rising judicial vacancies. According to the data given, it is provided that there is 1098, which is the sanctioned strength of the judges across the 25 high courts of India. 1098 judges. Out of that 465 number of sanctioned posts were vacant as of September 1. So we can see this particular thing, that the judicial vacancy stands at around 41% in the high courts, and because there are so much high vacancies, what is leading it, there is a judicial backlog that is coming. Fine, there is a very slow pace of justice, and understand this thing, justice delayed is equal to justice denied. Now if I tell you the number of pending cases into the Indian cases, around 3.5 crore cases are pending, and according to certain estimates, it's provided that India will take 400 years, 400 plus years to dispose these particular cases. Now, when we talk about, guys, the criminal justice reforms, first of all, what is the meaning of the criminal justice system? So, criminal justice system includes, it includes police, it includes investigation, it includes police investigation, it includes judiciary, and it includes the prison. So police investigation wing, judiciary and prison, all these will be included into the criminal justice system. And we see that the criminal justice system of India is not very much good. There are many loopholes. So therefore there is a need of the criminal justice reforms, and therefore the reform in judiciary is also very much important. And within the judicial reform, the judicial appointment is one of a issue that's there. Fine. And I told you that 41% vacancies are there into the High Court. Fine. Now, see this particular thing, that when we talk about the appointments into the High Court, they will be done onto the basis of the collegium. Who will be recommending the name of the judges to the President of India, and President of India then has to appoint those judges. Now, basically the Supreme Court is unhappy with the central government. Supreme Court is saying this particular thing, that we have recommended so many of the names, the collegium has recommended so many of the names which are to be appointed as the judges, but the central government is not taking any decision on that particular thing. Central government is silent, which is leading to many of the problems. Now what has happened? See this particular thing. What has happened? Supreme Court said that government is using silence and inaction as some sort of a device. Okay, it is basically worthy candidates, prominent lawyers, fine, they are not being elected. Now see this particular thing. The Supreme Court says this thing, that first of all, convincing many of the eminent people that they should assume the seat on the bench, it is very difficult. After that, when their names are sent to the government, to the President of India, that they should be appointed, then there is a silence. Okay, they are not taking any decision in this particular thing. And at the same time, the vacancies are at the record number, which is very bad, which is condemnable, fine, which is not very much good. So this is the Supreme Court which has expressed its dissatisfaction on this particular matter. Fine. Now guys, these particular kind of things, for example, I had given you the data here of the judicial vacancies. These are certain things which you should use in your answer writing. Okay. Now some of the judges courts are also without the regular chief justices. The names have been given, but I'll not say you should go too much into the details. Fine, because approximate number you should remember. Now moving to the next article. Autonomy oils the wheels of the higher education excellence. Now this particular article will see with respect to the GS paper number 2, issues related to education, within the education, higher education in India and issues. Now let's discuss this particular article. First of all guys, when we talk about the higher education in India, often we find this particular thing, that India's higher education sector has certain problems. Number one, often it is said that there is a lack of innovation. Though recently India ranked at 40 under the global innovation index, but still there is a lot of scope on innovation. Second, research and development in higher education is often lagging. Third, we find this particular thing, that the present education which is being provided into the higher education, many a times it doesn't has the applicability into the real world. Then fourth, see this particular thing, the graduates which are getting graduated from the higher institutes, often they are not employable. According to the India Skill Report, just 46% of the graduates are employable. So we see that there are the redundant curriculums also. So these are some general problems in the higher education setup in India. Though all of them are not discussed in this, these are not discussed in the article, but you should know about the generic problems that are there in every sector. Fine, education, economy, employment, manufacturing, agriculture. These are some things which should always be there in your mind. Now, see this particular thing. Now, the article talks about that none of the Indian institutions of the higher education has ranked in the top 100 list of universities. Okay. Now, when we talk about the top universities in this direction, there are the different rankings that are released. For example, QS World University ranking is released. Then there is a Times Higher Education ranking that is released. Then there is the academic ranking of world universities, AWRU, academic world ranking of universities. So these are the different rankings that are released. In these particular rankings, Indian institution don't fare very good. Now see this particular thing. Recently what happened, 2023 edition 2023 edition of QS World University Ranking was released. We have discussed it also in the newspaper, and I will ask the people who are watching the newspaper analysis regularly, please tell the name of those 3 institutions which ranked into the top 200 into the QS World University Ranking. Fine, we have discussed it. So 2023 QS World University Ranking was released, and in that only 3 of the Indian universities were ranked in top 200. In 100 we did not had even one. This is very problematic. Now little bit about the QS World University Ranking. So they are released by the Quacquarelli Simons, QS. Okay, now in this particular direction, there is also the Times Higher Education Institutional Ranking that was also released, Times Higher Education, and it placed only one Indian institution among the top 400 in the world. So here the condition is even bad, and a similar situation is there onto the academic ranking of the world university. So problem is that our universities, institutions are not ranking in the top institutions of the world. Now, when we talk about the universities or the institutions that had ranked good, what are these institutions? These institutions are the institution of national eminence, national importance. Most of the institutions are the institution of national importance. Now, INI is a tag that is given by the government of India to the premier institutions. Now, in these INIs, there are the IITs to be very specific, which are ranking into the top. Okay, now understand this particular thing, that when we talk about the IITs, why they rank into the top, there are certain reasons in this particular direction. Reason number 1, they are better funded. Reason number 2, they are self-governed. They enjoy greater degree of autonomy. Fine, this is very important, autonomy. Now, what is autonomy? Just an additional concept I am giving you, not mentioned in the article, therefore, as well as not here, you can write it in your notebooks. There is the Gajendra Gadkar Committee. Gajendra Gadkar Committee. And Gajendra Gadkar Committee has explained the concept of autonomy in the higher institutions. Gajendra Gadkar Committee had provided this particular thing, that autonomy is not a legal concept, rather the autonomy, it is an academic concept. It means that the institutions want that they should be given the power to decide their curriculum, to decide that what type of teachers they want to hire, what will be their pedagogy, what will be the method in which they'll take the exam. So on these particular matters, the institutions needed to be given autonomy. This is the Gajendra Gadkar Committee which have explained the concept of autonomy. Now when we talk about the IITs or the institution of national importance which are getting the good ranking, we see that many of them have a huge autonomy with them. They fall outside the regulatory purview of the UGC, as well as they are outside the AICTE. So they can innovate, they can decide on many of the factors. Now when we talk about the UGC, fine, funded through the UGC, fine, the universities are funded by the UGC and they are under the strict regulatory regime. For everything they need to take the approval from UGC. UGC will be giving the compliances, fine, all of them they have to follow. Now you see this particular thing, good, we need to have such kind of a regulatory system, but understand the education is now evolving a lot. Every day new technologies are coming, every day there are the new ecosystems that are coming, some, fine. So understand that the institutions need to be very dynamic, and when you have to comply to some higher institutions, often that dynamicism will be lost. So therefore this is provided. Now it has been provided that basically it has been provided that this UGC regulations, AICT guidelines, they encompass almost all the aspects of their functioning. What type of faculty they need to hire, how they need to have the pedagogy, what is to be taught, everything is dictated by the AICT UGC. So there is a kind of a micromanagement of these particular institutions that happen. And in this particular direction, the new education policy, National Education Policy 2020, also highlighted the need for autonomy that is to be given to the higher institutions. By that these institutions will will be able to perform, will be able to meet the demands of the 21st century. This is something that has been provided. Now, the National Education Policy of 2020 had provided that academic and administrative autonomy are essential for making higher educational multidisciplinary institution more creative, more innovative. Fine. So this is something which is very much important. But in India, the autonomy is not provided much. We provide autonomy via the Institute of Eminence scheme, via the Institute of National Importance. Fine, we provide the autonomy. Fine. If I talk you the new education policy, little bit of an additional concept, please note it down separately. National Education Policy 2020 had divided autonomy in three types. Fine, and it had talked about the concept of the graded autonomy. The graded autonomy. Now, what is this graded autonomy? NEP provides that there are the three types of the institutions that we have. 1, 2, 3. Institution number 1, where the research is most and little bit teaching is there. Fine. For example, research is most. For example, IISc Bangalore. So in IISc Bangalore, the research will be given. Research is something which is more important. Teaching is also there, but teaching is not that much that much significant part of these institutions. Then second type of institutions are there where the teaching will be more and little bit research will be there. And third are the degree awarding colleges. Now, the NEP provided this particular thing that these first category of institution where research is more, their maximum emphasis is to be given onto the autonomy. They should be given highest autonomy. Then they should be given the second category, they should be given gradually little bit more autonomy, and the degree awarding colleges, they are needed to be regulated. Less autonomy can be given here. So NEP has also preferred the idea of the autonomy. Okay, so therefore these autonomy, if the institutions will get the autonomy, what they can do, they can design their own courses and can meet the present requirements. Secondly, they can hire the talented faculty both from the India as well as from the foreign countries. Fine. Third is that if they have the autonomy, they can innovate on their courses, which will give them a considerable strength. So this is something that has been provided in this article. That is all about it. And now we'll move to the next article. In EWS verdict, a discrimination antithetical to equality. Now, this particular article we'll see with respect to the GS paper number 2, social justice, issues of affirmative action, or the issues of reservation. Fine. So recently the Supreme Court's judgment has come on the constitutional validity of the 103rd Constitutional Amendment Act. So we'll see all these issues as what they are all about. Now see this particular thing. Recently, the Supreme Court has given its judgment and had upheld the 103rd Constitutional Amendment Act. Now, what was this 103rd Constitutional Amendment Act? In case if you don't know, this particular Amendment Act provided 10% reservation to the economically weaker sections. Now, economically weaker sections will be the ones whose household annual income is less than 8 lakh rupees, and there are the other land holding. Fine, the property that they are having, those conditions are also there. Fine. So basically 10% EWS reservation was provided. Now understand, the article is talking about that, see, the Indian Constitution, it is based on certain ideas, it is based on certain premises. Now what are the most important premises? Number 1, equal treatment has been promised, personal liberty has been promised, freedom of expression, religion, all these things have been promised by the Indian Constitution. But how actually they are to be given onto the ground, for that particular thing, the courts will come in between. Courts will give the real meaning to all these particular expressions that are there. So this is something. So court from time to time will define what is equal treatment, what is the scope of liberty, what is the scope of freedom of speech and expression, how much speech is allowed, how much speech is not allowed. And when the judges are interpreting the Constitution, at times there can be the possibility that judges can arrive at the different conclusions. They can arrive at different conclusion. They can come with some different interpretations. That can well happen. This is a possibility. Number 1. Now, second thing is this, guys, that even in this particular matter, 103rd constitutional matter, which is taken by the Supreme Court has come out with a 3/2 majority. 3 judges have favored that yes, 103rd Constitutional Amendment Act is valid. 2 judges said it is not valid. So here also the conflicting viewpoints are there. So often it will happen. Now, when we talk about the present case of the Supreme Court, fine, Supreme Court provided that the amendment 103rd Constitutional Amendment Act, which was introduced in 2019, which changed Article 15 and Article 16. Actually, Article 15 subclause 6 was added and Article 16 subclause 6 was added. And fine, by that 10% reservation was given in government jobs, educational institution for EWS. Fine. The Supreme Court said that okay, that has happened, and what it has done, it has mandated what has happened. It has provided this particular thing, but at the same time, it also provided that the citizens other than classes that are already eligible for reservation, they will not be counted in EWS reservation. What it means in very simple words, it provided that the citizens who are getting reservation elsewhere, for example, if a person is from scheduled caste community, OBC community, they are getting reservation already in their own quotas. For example, in India, for the scheduled caste, scheduled tribe and OBCs, we have reservation in this kind of a manner. Scheduled caste are given 15% reservation, scheduled tribe are given 7.5% and OBCs are given 27% reservations. So if a person is getting a reservation, if a person is scheduled caste, that person cannot claim the reservation again in the EWS category. That is something that is provided. Okay. Now, understand this particular thing, that when we talk about the government's powers with respect to amending the constitution, so here what actually was done in the 103rd Constitutional Amendment Act, Article 15 and Article 16 of the constitution got amended. So with respect to the amending power, you need to know one very important judgment, and you might be knowing it also, 1973 Keshwananda Bharti case. In the Keshwananda Bharti case, Supreme Court provided that the Parliament's power to amend the constitution is not unlimited. Only that particular part can be amended by the Parliament, which is not the basic structure. So basic structure cannot be damaged. Basic structure cannot be damaged. Fine. Now, as this particular case was going on, fine, with the validity of the 103rd Constitutional Amendment Act was challenged. There was Janhit Abhiyan versus Union of India case. Now, in this Janhit Abhiyan versus Union of India, what has happened? The petitioners has challenged the 103rd Constitutional Amendment Act, and actually this challenge will become our criticism of the EWS reservation. Fine. So listen very carefully. What are the grounds on which they have challenged? Number one, they provided that providing reservation on individual economic status undermined the original logic of reservation. Now, what was the original logic of reservation? See this particular thing. It was provided that reservation is being given to make up for the historical injustice that had happened in the society. Now, the scheduled caste people, they were never allowed to get education. They were not allowed to access the community resources. So there were the historical injustice that had happened with these people. So therefore, they were given the reservation. Today, what has happened? Reservation has been given on the economic criteria. Reservation has been given on the economic criteria. So therefore, the question that comes here is that basically there are two type of things. There are the structural. Fine. So it has been said that there are two things. There are the social and economic conditions. Now, social conditions are something which are to be made up. Fine. Sometimes there in the past some injustice has happened, and we need to make up for that particular loss. Basically, there is a reparation that is to be done. Okay. So that for that reason, it is justified. But on economic ground, now economic ground is a structural inequality that is existing in the society. That is something which is to be addressed by poverty alleviation scheme. Giving reservation on that particular category is not something which is very much justified. Fine. Moreover, see this particular thing. There is also the Indra Sahani versus Union of India case of 1992, which provided that economic status cannot serve as the criteria for identifying which section of people qualified as backward. Fine. So very clearly the 1992 judgment provided, because at that point in time also the reservation was given on economic criteria, and Indra Sahani judgment provided that this cannot be the ground. So, and now what you have done, you have again used the economic ground. So therefore it is a constitutional challenge that has come. Social categories, it is justified because historical injustice have happened, and to make up for that justice, it is being done. Okay. Then moving on. Then the other challenge that comes here is that this particular amendment act is discriminatory. Why? Because it has excluded the SCs, STs and OBCs from the EWS reservation, and it is the violation of article 14, 15 and 16. Fine. So therefore it is the violation. Now basically the Supreme Court, the government has provided that intelligent classification can be done, but this is a criticism anyhow. Then 50% cap. Now, in the Indra Sahani case of 1992, Supreme Court provided this particular thing, that the reservations cannot exceed 50%, more than 50%, because then it will lead to inequality to the unreserved categories. Fine, but now what has happened? 50% cap has been breached. How 50% cap? Because you see this particular thing already. We were giving these much reservations that I have provided you. It was 49.5% reservation. If you add the 10% reservation of EWS, the reservation reaches to 59.5%. So 50% cap has been, just a minute, let me zoom out. So 50% cap has been breached. This is the challenge that's coming in this particular direction. Fine. Now, the article is talking about the majority of bench has defended the 103rd Constitutional Amendment Act. They have provided this particular thing that see, now historically we have believed only in the social ground, that it is a ground for reservation, but now the new criterias are also coming. Okay, and we need to understand reservation into the present times. So it's not a kind of a thing which will never change, that reservation will only be provided onto the social grounds. Economic ground it can be there, new criterias can be defined. So the Supreme Court have justified this particular thing also. So there is a reasonable classification. In reasonable classification, guys, it has been provided that some categories can be treated differently. Right now what is happening within the EWS reservation, SC, STs and OBCs are not included. SC, STs and OBCs are not included. Others are included. So what has happened? A kind of this group has been treated differently than this other group of SC, STs and OBC. So kind of a classification has been made. Now this classification can be made. It is provided in article number 14, but the classification needs to be an intelligent ground. Classification needs to be on the basis of some rational ground. And government has provided that there is a rational ground. What is the rational ground? That see, these people have already been provided reservation. Okay, so to include them here will not mean more of a sense, because here already many more people are being included. So this is something that has happened. Fine. And guys, in this particular direction, there will be the lot of editorials that will be coming into the newspaper. Now you see this thing, we need to have certain arguments in our favor as well as against. Every article, you don't need to sweat out a lot on every article. Fine. That is all about it. And now we'll move to the next article. Research first. So this particular article we'll see again with respect to the GS paper number 2, issues related to education, and within the education, issues related to the higher education. We'll see this particular article. Now, first of all, what is the development that has happened? So guys, the development that has come in this particular direction is that UGC, fine, UGC has decided to remove the mandatory requirement of getting research paper published in peer-reviewed journals. Now, what it means, let's keep this article at aside and let's talk about. So basically, guys, if you are pursuing the PhD, now basically in the PhD, you have to write thesis, fine, you have to write thesis. Now these theses, fine, they have to be published. Up till now, these theses were to be published into the journals. In the journals, they will be peer reviewed. Peer review means that the people who are also pursuing the same kind of within the same stream they are pursuing, fine, they will review. They will point out that okay, in your research, in your thesis, this is the problem, that is the problem. They will be pointing out that particular problem. So in the peer reviewed journals, you need to publish your thesis, and after that only you will be given the PhD degree. That is the norm that was there. It was provided by the UGC. Okay, now see this particular thing. What UGC had done? UGC had removed this particular mandatory process. Why UGC has removed this mandatory process? UGC actually identified that in this entire setup, there was some distortions that were going on. What happened? the people who are pursuing the PhD, what they'll do, they will publish their research, they will publish their thesis actually in those kind of a journals which are not very reputed journals, very shady kind of journals. For example, tomorrow I can start a journal where what I'll do, I will say that all the people who are just doing PhD to get the name of doctor, fine, prefixed before their name. Now many people have no interest in research, just why they do PhD, so that they get a title of doctor. Fine. So all the people who are aspiring for that particular thing only, you send your papers, thesis to me. I will publish it in my own thinking palette journal. Now nobody reads that thinking palette journal. Fine. We will just be fakingly will be reviewing your journal, and then you can just go and submit your thesis. You will say that you have asked me to publish that journal. I have published it into the thinking palette journal, but actually this thinking palette journal might not be a very reputed journal. Okay, might not be a very reputed journal. So actually the UGC recognize that the PhD scholars are publishing their thesis in any bogus kind of journals which is going on, and this is actually not serving the purpose. Okay, so therefore they have removed this particular thing. Fine. So what happened, there was an unhealthy practice where scholars were paying substandard predatory journals to publish their papers without sufficient review, and it has weakened the quality. It has weakened the quality. Okay, this is something that is going on. Now this particular removal has accepted a kind of a practicality in the education system that is going on. Moreover, the UGC's new directives that have come, they have also recognized this particular thing, that there is also the diversity in the academic disciplines. Now understand this particular point. You see this particular thing, everywhere just publishing into the journal might not be a preferred way. For example, see, in the humanities there are the monographs that are published. What is a monograph? Monograph, it is a piece of writing on one specific subject with one specific specialty. I have a specialty on one particular subject. I will be writing extensively on that particular thing. What I believe, I'll write entirely on that particular thing. That is a monograph. Sometimes monographs are accepted in humanities. Now you just take one more example. In the computer science, researchers value conference presentations. Fine, if you have come out with an idea, you need to present that into the conferences, there it will be appealed. Fine. Sometimes patent obtained are a better indication of quality. If I am doing some research, how many patents I got, whether I have published or not doesn't matter, but the number of patent I got will show the quality of my research. I'm a computer researcher, how many presentations I have given, that will prove the research. So always only one way that you just publish it, it is not a standard. There is a lot of diversity in the higher education, and in that particular thing, we need to accept that only publishing might not be one way. Okay, now see this particular thing. It has also been provided that removing the mandatory requirement will allow for more innovation. Actually, how? You see this particular thing, that actually, see, there is no mandatory requirement. Fine, let's take one example. Suppose I am running an offline class and I announced one test. I took the test and I asked everybody that you please write the test and you can submit the papers. Now if let's say it is a surprise test, many of them, what they'll do, either I say that submitting is optional. If you submit it, I'll review it, otherwise not at all a problem. Now many of the people, what they'll do, they'll not write. Many of the people, then they'll write but they'll not submit, because they know that their quality of answers might not be very good. But the good students who have written some very good quality of answers, what they'll do, they'll submit. Fine. So basically what has happened, when we have removed this particular condition, still some scholars are doing PhD just to, because they have interest in research. They are not doing it just to get the name of doctor attached. So they'll still publish, and they'll publish actually into the reputed journals. So what will happen, these bogus kind of journals that existed, for example, I told you the thinking palette journal that was there, which was just not a very good journal, these kind of things will not be there then. Okay, and people will still be publishing, and that will be the mark of the good researcher. That is something that is then. Okay, so this is something which will be coming. So this is a kind of a new and a fresh and innovative approach has been taken. Okay, so that is all. Now these particular kind of things can be used as a case study in our answers. Now moving to the next article. Yellen pushes for global cooperation on the regulation of cryptocurrency. Now guys, when we talk about the cryptocurrencies, we see this particular thing, that now the cryptocurrencies has become a major financial instrument cryptocurrencies are being used for many purposes, and even in many of the countries cryptocurrencies are being accepted also as a fiat currency. That is also going on. But at the cryptocurrency there is no global consensus whether the cryptocurrencies are right or not. There is no global consensus on that particular thing. Fine. Now, when we talk about the cryptocurrencies, guys, cryptocurrencies are the virtual currencies which are based on a cryptographic code. Okay. We have many examples of the cryptocurrency. For example, Bitcoin is a cryptocurrency, Ethereum is a cryptocurrency. Now, when we talk about the India's stand on to the cryptocurrency, in India, the cryptocurrencies lies in a gray area. Okay. What had happened just 2 years back? Just 2 years back, the cryptocurrencies got banned in India on the basis of a RBI recommendation. But actually in 2020, Supreme Court said that you cannot simply ban the cryptocurrencies. Fine. So after 2020, cryptocurrencies were allowed, they were being traded, they were being exchanged, they were being sold. Fine. And 2020, 2021 was also the time when the cryptocurrencies reached at its peak. Since then, the cryptocurrencies are coming down. Now the cryptocurrencies are being used by the people. Actually, there are many concerns in the cryptocurrency. What are the cryptocurrencies? What are the cryptocurrencies concerned? Number one, these cryptocurrencies are not backed by any central bank. Fine. For example, Indian rupee is backed by the central bank, that is RBI, but these cryptocurrencies are not backed by. Fine. It is just a code whose value is just increasing on just a speculation. One. Second thing, the cryptocurrencies, they have a lot of anonymity associated with that. Okay. And because of that particular thing, these cryptocurrencies often are being used into the terror funding, terror financing. So the cryptocurrencies are a nuisance also that is there at some times. So we need to regulate cryptocurrency. But see, how to regulate cryptocurrency? A physical currency always flows from bank, or it will be flowing in physical format. Now, if I want to go to London, fine, I can either, how I will take 100 crore rupees? Either, first of all, 100 crore rupees is a big amount that I spoke. I want to take 1 lakh rupees London to London. How I will take? Either I can put it in my pocket and I can take it. But when I'm going by plane or by anything, fine, I have to be, I will be frisked. They will see this money and will ask that, okay, how you brought this money? How you got this particular money? Fine. Secondly, if I'll transfer that money by the bank, then also there is a legitimate channel by this, these monies are traveling. So there is not a problem, but the cryptocurrencies, these just travel onto the internet. They don't travel essentially by the banks. So regulating these cryptocurrencies is very problematic because the entire world need to cooperate at the same time. Otherwise, they cannot be regulated. Fine. Now see, for that particular thing, there is a global cooperation that is needed. And guys, actually India was also, there was the news that was coming few months back that India might come out with a law on the cryptocurrency, but as of now we did not had come on that particular law, because we said this thing, to regulate cryptocurrencies we need to have the cooperation of other countries also. That is one thing. Now I hope that this background is clear in your mind. Now keep this background in your mind. And what has happened, the United States Treasury Secretary Janet Yellen has visited India. And as the Treasury Secretary Janet Yellen has visited India, she had met the Finance Minister of India and has provided that the cryptocurrencies are to be regulated. Cryptocurrencies are to be regulated, and for that regulation, we need to cooperate. All the countries need to come together and they need to cooperate. Is it clear or not? Now, understand this particular thing, that the cooperation is needed. Moreover, the second thing that has been talked about is that FATF, IMF, they also need to cooperate on making the inter-boundary transactions more convenient. Now you see this particular thing. Exports, imports are happening between the countries, and when the exports and imports are there, their payments. Fine. So basically, we need to take the steps to reduce the cost of cross-boundary payments, cross-border payments. Fine. In this particular direction, the Financial Stability Board, Financial Action Task Force, multilateral banks, IMF, bilateral exchanges, they need to make sure that the cost of transactions are reduced. Okay. The cryptocurrencies, their role is also to be assessed by them. So this is something that is needed. So just a cooperation is needed, and an exchange, a talk has happened, and in this particular thing, we need to cooperate. Okay. Understand this thing, guys. E-rupee. E-rupee is not a cryptocurrency. There is one comment, E-rupee, Aditya, E-rupee, yes, it is an initiative, but is entirely a different initiative. Okay, E-rupee is not a cryptocurrency. Few days back, India also said that we will come out with the CBDC. Okay, now basically we are talking about the digital currency. Now the digital currency will be the digital counterpart of the rupee also. Okay, it will not be a cryptocurrency. Please keep it in your mind, because many number of times there are many confusions that are there. Okay, now that is all about it. And then we have the mains practice question. Balraj Valmiki, clear it clear about cryptocurrency. Fine, so I hope you are saying that it's clear. Fine, good. Mains practice question for today. The new education policy 2022 seeks to completely overhaul the higher education system, and to attain this objective repeatedly emphasizes the need for institutional autonomy. In this context, discuss how the institutional autonomy are a sine qua non. Sine qua non means which is indispensable in promoting creativity and innovation. Okay, so this is a 10 marker question. Okay, and this question is for GS paper number 2, issues related to education. So that is all guys for the today's newspaper analysis. I hope that you have liked the video. I hope that you are like the video, and you might be getting some value addition by the videos that we are taking. Fine. So guys, if you have liked the video, please do hit the like button. It takes really a lot of hard work to prepare the video and the content, the PDF part especially. So please like the video if you have liked it, and please do leave your lovely comments, and please spread the initiative, because see, the initiative's viability only depends on this particular aspect, that how many people actually we are able to cater to. Fine, so that is all about it. Thank you so much. Now we'll be meeting on Monday. Till then, please take care of yourselves. Thank you so much.